Thank you.
SJC-11564, Michael Okeke and another, the Dynamex Operations East, Inc.
Good morning. My name is Sarah Herlihy, and I represent the appellant, Dynamex Operations East. With me today is Guy Tully. I would like to reserve 5 minutes for rebuttal. There are two main legal issues before this court on this appeal. The first is whether Dynamex waived its right to enforce an arbitration agreement between itself and one of the plaintiffs in this action, Willie Carl Paquiat. The second issue is whether, with respect to the facts of this case and the legal claims at issue, the arbitration provision in the agreement with Dynamex is enforceable. On both of these issues, the starting point for the analysis is the same. When considering whether to enforce an arbitration provision, any doubts should be resolved in favor of arbitration, whether the issue before the court is one of waiver or one of enforceability.
Just by way of factual background, how much time passed after the action was filed before Dynamex invoked the arbitration clause?
So we were served, Dynamex was served in June of 2010, and they filed their motion to compel, or served their motion to compel on May 2nd of 2011. But we would argue that the entire...
How much time is that? That sounds like
11
it's
months.
5 years.
I'm sorry, it's...
2010, it's 11 months?
2010, it's, I'm sorry, the action was filed on, we were served in June of 2010, and we moved to compel arbitration in May of 2012. So a little less than 2 years.
2 years, okay. Sorry to interrupt
That's
you.
okay, sorry, Your Honor.
Now, if Mr. Okeke was the only party, and the court was spending 2 years on this matter, and you say, oh, we just went into a file and we just found that there's an arbitration agreement, would the court not be able to say that you've waived it?
It would depend on the facts of the case, Your Honor. So the plaintiff at issue here is Mr. Paquiat, who had the agreement. And if Mr. Paquiat,
okay.
if there had been 2 years of litigation with
But
Mr.
if he was the sole plaintiff, and the court basically had wasted 2 years on a case that you say should never have been to court, is the court not powerless to say, you've just wasted my precious time, but it's not okay, quoting Mr. Dillon?
It's not powerless to do so, Your Honor, but there is a legal standard that they need to use to analyze it, and that's whether there's been prejudice to the plaintiff and whether there's been a use of the litigation process that is adverse or inconsistent with the arbitration process or the arbitration right. So there is no time frame for asserting an arbitration clause under either the FAA or the MAA. It's an analysis as to whether there's been a waiver, which again requires essentially a two-pronged test, whether there's been prejudice to the party opposing the enforcement of the agreement, and whether there's been some use of the litigation process that's inconsistent with the right to arbitrate.
And with regard to the issue of prejudice, I mean, you engaged in considerable discovery. Would that discovery be available in Texas?
It would, Your Honor. In fact, nobody is arguing here that Dynamex would not have been entitled to obtain the discovery from Mr. Paquiat that it sought here. And it's very limited discovery we're talking about. We're talking about one set of document requests, one set of interrogatories, and it's also discovery that would have taken place anyway because Mr. Okeke has the same claims, was dealing with the same company, so that discovery with respect to Mr. Okeke, who does not have an arbitration provision, would have taken place anyway. So this notion that we're using the court's time and resources for 2 years simply isn't supported in the record here. And again, we'll talk to you a little bit about the reason for some of the delay. But during the period of time between the time we answered the complaint in August of 2010 and the time we moved to compel arbitration in May of 2011, we asked the court to make no substantive decisions in this case. We did not move to dismiss as to Mr. Paquiat. We did not seek summary judgment as to Mr. Paquiat. We didn't make any discovery motions or seek a discovery ruling from the court as to Mr. Paquiat. So the notion that the court devoted 2 years of time simply isn't supported by the record here. And your point is well taken in terms of time, but time alone is not what the standard is for the court to consider on the waiver issue.
If I can turn you to the substantive law of the state of Texas.
Yes, sir.
Which is what the contract says.
Correct.
the arbitrator says the substantive law of the state of Texas is that I shall apply the wage law in the state of Texas, we don't have the same wage law that Massachusetts has, you lose. Plaintiff, you lose.
So our
No
position,
appeal.
Your Honor, is that, the provision at issue here calls for the application of, as you said, the substantive law of Texas, but that includes the choice of law provisions or the conflicts of law provisions of Texas. Now, neither the specific choice of law provision in this contract nor the arbitration provision in this contract has language that excludes the Texas choice of law provisions.
Yeah, but two points, I think. One, the general contract says the law, capital L, of the state of Texas shall apply. And then when you get to the arbitration, it says the substantive law of the state of Texas. So one might read that and say, that really means something different, and it means really the law of Texas, not its conflict of law, choice of law principles, but the statutory and case law of Texas as it applies to wage things. And number two, which I think is Justice Gantz's last point, whatever the arbitrator does, not only is it not reviewable, he doesn't even have to say what he did. He just has to rule. So how are we ever going to be able to know what the arbitrator did? And it's a single arbitrator in Texas, if you don't,
So let me take those 2 points separately, Your Honor. With respect to the substantive law, neither party, frankly, in this case, has pointed you to a case that says that language in a provision requires the application of the substantive law without reference to the conflict of
It's
laws.
just, it's an ambiguity that we don't have any control over.
You do actually have control over it, Honor. Number one, we haven't ever argued that anything but the substantive law of Massachusetts applies to Mr. Pacquiat's claims. The case below now has gone to summary judgment and class certification, and on those issues, we have never argued that anything other than
Are you
the
saying that
Massachusetts Wage Act is at issue.
you would say that if this goes forward in arbitration in Texas, you would say to the arbitrator, we agree with Mr. Pacquiat that the wage law, Chapter 149, Sections 148 and 150 apply in this case? You would say that?
Well, we don't have to concede that point because you can make that decision for us if you're concerned about the application of Texas law.
Tell me, we've never said it doesn't, so I'm just trying to push you on that.
And I understand, Your Honor, and we have never taken the position that Massachusetts law doesn't apply. You're asking me to concede that, and I believe we can concede that here. But in terms of the case, Your Honor, if the justices are concerned that the application of Texas law would somehow deprive Mr. Pacquiat of a right, you can do what you did in System 4, which is simply use the severability provision in the agreement and sever it.
But it's different to sever a provision that says no, no punitive, or no multiple damages, I forget which, okay. Sever that, means they're available. Then saying we're going to sever that Texas law applies. That doesn't necessarily mean that the arbitrator wouldn't apply the choice of law provisions and come up with a different view.
Well, again, Your Honor, you can conform this contract to say that, the Massachusetts Wage Act, under the severability provision, you can even sever simply the word substantive under Texas law and then have them apply it. You're right that you can't guarantee that applying Texas law, even the conflicts of law principles.
Even make it probable, I don't think.
No, but this court, when it considered this very issue in Malia, said it would be the rare case where modern choice of law principles on these facts wouldn't simply take somebody back to the application of Massachusetts law. And
That's
we
because there was a
concede that.
lot of, there was a fair amount of law about New York's law that could, I suggest, could persuade us that indeed it seemed highly likely that in Malia, which was not an arbitration case, the court in New York, subject to appellate review, would be likely to apply Massachusetts law to those questions. I don't think we have that here.
You do have the case law before you that Texas applies modern
Case
choice
from
of
1990.
they apply modern choice of law principles, and this court acknowledged that those conflicts of law principles are well developed. When in Malia they said it would be rare for a forum applying modern conflicts of law principles on facts similar to these not to apply the Massachusetts Wage Act. And again, my client will concede that Massachusetts law will apply, it should be applied by the arbitrator to the Wage Act claims in this case. We've never been asked to concede that before, but if that's a concern of the court, we will.
So what does substantive mean?
Here, the substantive means the entire body of Texas law, which would include the conflicts of law principles. But again, for purposes of this argument and for purposes of Mr. Paquiat's claims, we'll concede that the application of substantive Texas law will bring you to the application of the Massachusetts Wage Act to his claims.
And is that going to be binding on the arbitrator? The arbitrator may say, I'm from Texas. I know the law of Texas. You didn't say choice of law. You said substantive law. I'm going to apply Texas law.
Well, the arbitrator is a creature of the party's contract and the party's agreement. So certainly if we concede it, and that's what plaintiffs are arguing should be applied, the arbitrator should apply that law.
Ms. Hurley, we'll have to leave it there briefly. You'll be back.
Thank you, Your Honors.
Again. Thank you.
Thank you, Your Honor. My name is Harold Lichten. I represent the plaintiff. To take the final point, it is nothing short, really, of egregious for, after 4 years of litigation, for the first time after briefing this issue, both in the lower court and in this court, and saying that Texas law would apply, however, the arbitrator might apply Texas choice of law principles, even though it's an arbitrator, not a court, and you would have no control over that, to now say at oral argument that now we'd concede, since the oral argument is going bad for us, that Massachusetts law would apply. You're bound, I believe, to what's in the record before you, and after 4 years to concede that in a last final-ditch attempt to avoid the lower court's decision being affirmed, I think is egregious. Now, I want to point out that, as you've pointed out, that we're not talking about an court form. It may be true that a Texas court would apply the restatement of law, conflicts of law, section 187. But arbitrators, and this is critical, are creatures of contract. They're not creatures of the judicial system. And arbitrators are only given that jurisdiction which the contract gives them. And they have to apply the law. And we've cited to you the Seventh Circuit decision from Judge Posner, a very learned judge on the Seventh Circuit, that said it would be reversible error for a court, even though he's a creature of this contract and forced to apply the law that the parties have chosen, to all of a sudden say, well, I'm going to apply a different state's law.
But just, I mean, if the court in Malia says we're striking that restriction on damages position, I take it if a court does that and in a sense negatively reforms the contract by striking a provision, when it goes to arbitration, the arbitrator is bound by what the court has said, correct?
Yes, Your Honor, but this is not, as you've pointed out, a situation where there's one provision, that the arbitration agreement is otherwise fair and reasonable, but there's just one provision, like the exclusion of multiple damages, that can easily be severed. As we pointed out in the decision of Justice Roberts when he was sitting on the D.C. Circuit in the Booker case, which is in the amicus brief, and in the recent decision, which we submitted to you in Newton, it's one thing for a court to strike a fair arbitration agreement that has one little provision that may be severable. Here, this case, to use Justice Roberts' decision, is pervasively infected with illegality. And you wouldn't be reforming, you wouldn't be severing a provision.
Besides this issue, what else are you referring to?
Sure. Well, first of all, it's the requirement that he goes to Texas. Okay. That's a procedural and administrative barrier that is insurmountable for him, especially since there's a class action waiver in this case. We're not claiming the class action waiver is...
But that's a sort of forum selection clause, right?
No, Your Honor. We're saying that under the Supreme Court's decision in Italian colors and under Justice Gantt's decision in McGinnis, where the barriers to actually getting into the arbitration forum are set so high as to make it impractical to do so, that still grounds under McGinnis, your decision, and under Italian colors, Justice Scalia's opinion, to not enforce an arbitration provision. Here, there are multiple other provisions. One, he has to file the claim in Texas individually and go to Texas, even though he brings home $300 a week, has 2 kids, and has to work 6 or 7 days a week as a delivery driver. Secondly, there's a provision in Article 23 of the contract that the loser has to pay attorney's fees. Third, the provision is that the rules of the American Arbitration Association, commercial rules, not employment rules, apply. That requires the payment of fees up front by the person petitioning for arbitration. Those are several $1,000s because the arbitrator will require a deposit. And while there is a provision that's saying at the end of the day, the arbitrator could reapportion the fees if it's a financial burden to Mr. Pacquiao, that doesn't excuse him from paying the fees up front because it first has to get to the arbitrator. And therefore, if Mr. Pacquiao, as a reasonable man, is looking at this case as to whether to bring it, when there are all these objectionable provisions in the contract, including Texas choice of law, there's no way he nor any lawyer that he consults in Massachusetts or Texas is going to bring that claim, particularly since there's also a class action waiver.
So how do we get around Amex?
What?
How do we get around Amex?
In fact, Your Honor, Amex gives you the roadmap, as does Justice Gantt's opinion in McGinnis. And that's very simple because Amex says two things. First of all, under 9 U.S.C. Section 2, you are to enforce arbitration agreements, and here's the exception, save upon such grounds as exist at law or in equity for the revocation of any contract.
Does that mean unconscionability?
That means unconscionability or setting of the administrative barrier so high that the person could not get into arbitration, or, as both Justice Gantt said and as Justice Scalia said, because it would effectuate a prospective waiver of statutory rights. That is still unenforceable. And here, if ever there was a case where there would be a prospective waiver of statutory rights, it's here because it says Texas law applies. They've never before said that Texas law would not apply. If Texas law applies,
Let's leave that aside for us.
plaintiffs have no claim.
Leave that aside. Let's assume for a moment that that can be severed out.
Right. You still have the provision that says you have the fact that you have set the rule in Crocker versus Townsend that you will not effectuate a waiver under the special contract provisions of Section Chapter 148, Chapter 149, Section 148.
That's really a release, right?
What?
A release.
Well, but it doesn't have to be a release. Someone is not allowed to waive their rights under the Wage Act without specifically knowing that they're waiving their rights. And
Do you
there's
think
nothing in
that
this agreement.
survives? Do you think that survives?
Absolutely, because if you read footnote 6 of Concepcion, which precedes Italian colors, it says specifically that states are still free to interpret their laws in a way that prevents contracts of adhesion from creating barriers to enforcement of those rights. And most recently, in Cheveria versus Ralph's Grocery, which we provided to you on Friday, which is a recent decision, the Ninth Circuit said, as Justice Gantt said in McGinnis, that unconscionability still permits a court to not enforce an arbitration agreement so long as the reason for doing so is agnostic towards the issue of arbitration. That is, if it's a generally applicable principle that you would apply in any contract context, you may declare it unenforceable, but you cannot disfavor arbitration. The rule that you set up in Crocker has nothing to do with arbitration.
No, it's a Warfield. It has to be specific if you give it up.
That's correct, Your Honor. And in addition, the Italian colors also says, as McGinnis does, that when the administrative barrier to getting to arbitration is set high, particularly where it's a contract of adhesion, and you don't have equal bargaining power, which is certainly the case here, that is separate grounds, as Justice Scalia says, for still allowing a state not to enforce an arbitration provision. Remember, in Italian colors, there was no barrier to arbitration. It was just that once in arbitration, they would have had to hire expert witnesses that they said were too expensive. That's different from erecting a barrier which is insurmountable. I suggest that...
So the barrier that's insurmountable here is the costs.
Well, it's the going to Texas and the cost. It's the combination. Perhaps if it was just...
I take it those are both essentially costs.
Well, they're costs, but they're also barriers because Mr. Pacquiao, as he says in his affidavit, has 2 children, makes $300 a week, works 6 or 7 days a week, 60 hours a week, and there's no way that he's going to be able to go down to Texas and bring an arbitration. While Justice Scalia in Italian colors didn't use the word and travel 2,000 miles, I think that's a fair interpretation of what he said.
So can we strike the requirement that the arbitration take place in Texas and allow the arbitration to take place in Massachusetts.
I don't see how you can do that, and this is my point. At that point, you're not simply striking a unique provision of the agreement, you're reforming the agreement. And if you read Justice Roberts' decision before he got on the U.S. Supreme Court, he says once you start hacking away at that, you're creating an incentive for employers to put every objectionable provision in an agreement, knowing that when it gets to court, the court will hack away and sever them all. That's not
That's sort of the
severing
point
a
in-
provision, that's reforming a provision. And that's what the Ninth Circuit recently, in the Newton case, which was decided in December of 2013 after Italian Colors, refused to do.
Has, in Ralph's Grocery and, well, let's take Ralph's Grocery because I think that was an October decision. Any cert applied for? Do you know?
I'm sorry, I think cert has been applied for.
But it hasn't been ruled on.
It hasn't been ruled on, that's correct. But I do want
The
to just,
unconscionability has to focus on the arbitration clause itself. The arbitration clause has to be unconscionable.
that's right. And here, all these provisions about you bring the case in Texas, that you, the substantive law of Texas applies, you don't find these provisions in the contract itself. You find them in the arbitration clause.
Well, you find them in the contract itself also, but
Find them in
they're
the contract
specific
itself,
in
but
the
then they
arbitration.
reiterate them,
Yes.
and they actually say that if there's a conflict between the rules of the American Arbitration Association, which are bad enough, and the provisions of this arbitration agreement in the contract, that the arbitration agreement controls.
Now, this agreement was done for drivers, I guess it's the operations east, so by its nature, it's focused on drivers in the east, I gather.
I'm not sure of that. I assume so.
But certainly it was signed by Mr. Packwood, who lived in Malden, I gather.
Yes,
I mean, I
that's
take it
correct.
these are all people that are getting dispatched out of Woburn, correct?
The class that I was seeking to certify would have been Massachusetts drivers out of Woburn. That's correct. Justice Cantz raises an interesting question, whether the contract for the California drivers said they have to bring it in Boston, Massachusetts. I don't think so, but that would be a
That wasn't my
possibility.
point. But I mean, is it unconscionable because one person can't afford it if others could? I mean,
Yes, because since there's no class certified as of this time, and it was just Mr. Pacquiao that they moved to compel arbitration, the question before you is whether Justice Curran was correct in concluding that this would be an insurmountable barrier for Mr. Pacquiao, because that's all they were seeking to compel to arbitration at this point.
but the concern I have is if you have an agreement which says we're going to arbitrate it, say in Texas, you would say, well, it would not be unconscionable if there were a lot of money at stake and the plaintiff had money, but it's unconscionable because there's not a lot of money at stake and this plaintiff doesn't have money? It's unconscionable as to one but not as to another?
Well, I think in Amelia, you made that distinction, that you said there were sophisticated parties that made a commercial agreement, and you specifically referenced that. You've also referenced cases where there's a contract of adhesion, you take a different view.
Well,
I think it
the
is
difference between Dell and,
Machado,
yeah, is it Machado?
System 4.
Yes, right. Dell and Machado makes that point.
Right, that's correct. But Justice Gantz, I want to get back to your decision in McGinnis, because I've read it many times, and I think it directly addresses this issue. You say, quote, that under 9 U.S.C. Section 2, the court is allowed to invalidate arbitration agreements by generally applicable contract defenses such as fraud, duress, or unconscionability, but not by defenses that apply only to arbitration or that derive their meaning from the fact that an agreement to arbitrate is at issue. You also say, quote, contracts of adhesion are enforceable unless they are unconscionable, offend public policy, or are shown to be unfair in the particular circumstances, and you cite Concepcion, footnote 6, for that. Based upon that, I think if you look at that and apply that principle here, you have an individual who's very limited means, who's required to go to Texas, and in Texas, Texas law would have to be applied. I don't believe you can reform that provision or sever it or take their concession because it's in the agreement and they're stuck with what they put in the agreement. Your job is not to reform, it's only sometimes to sever small provisions that don't go to the heart of the arbitration agreement. And for that reason, I think if ever there were a case where Italian Colors and McGinnis allows this court to say, we're not going to enforce this clause, this is the case. And by doing that, you don't run afoul any U.S. Supreme Court decision. In fact, what you would be doing is consistent with Italian colors, and it would certainly be consistent with your decision in McGinnis.
Now, you've got 1 minute to discuss waiver.
Your Honor, my answer on waiver is that I do not think this case would be best served by your deciding this case on the waiver issue. The reason for that is because there are many other individuals who either will be part of a class if a class is ultimately certified, or who will bring their case individually if a class is ultimately not certified and denied. For those individuals, there will be no waiver because they were just brought into the case. And so the issue that I've been arguing for the last 15 minutes will be right back before you. And if you decide on waiver, will only mean that we'll be back in 4 or 5 months, because they will then seek to force all the other drivers to arbitration, and we really need guidance on that issue. Thank you very much.
Thank you, counsel.
Thank you.
So what my colleague is suggesting is that your decision in Malia permits you to send a case to New York for a New York court to decide it under a forum selection clause, but you don't trust an arbitrator to do that or make that same decision. That's treating an agreement that calls for arbitration differently than an agreement that simply calls for a New York forum, and that, under American Express versus Italian Colors, violates the FAA. So the treatment that he's proposing
But
would
in
run
that-
afoul of American Express.
I do recall in that case, we had sophisticated parties, right?
Well, here, you know, you're hearing the story about Mr. Paquiat from his counsel, but let's remember the agreements here. There was one negotiated in 2009 when Mr. Paquiat started working for Dynamex. He was going to college. He was commuting from Massachusetts to New York to go to college.
Not the chief executive of a company, however.
He's not, but he renegotiated his agreement in 2011, at which time he was represented by the counsel sitting next to me. He increased his commission rate at that time. So the suggestion that this is a contract of adhesion that was, or take it or leave it, imposed upon Mr.
All right,
Paquiat,
2011,
he signed a second agreement.
right, represented by whom?
Mr. Lichten, this case was ongoing at that time. He had counsel. So this again, the facts of this case are less like the, you know, adhesion contract type cases that we've seen. Mr. Paquiat is just a few credits shy of a college degree. He's no longer working as a driver,
All
from
this
what I
in the
understand.
record, counsel?
This is, well, the record was developed below before this case was
Right,
up.
so what
Summary
you're saying-
judgment would
What
reveal
you're
these
saying now
facts.
is not in the record.
It's not. It would be in the summary judgment facts, Your Honor.
Right, so, but that's not before us.
It's not before you in the appendix, no.
Right.
So, again, the notion that this is an unconscionable an unconscionable provision because it requires arbitration in Texas or a Texas forum is also not correct. What we have here is an individual who has brought significant claims for, you know, lost wages, for car payments, gas payments. The damages that they're claiming here are significant, both on an individual and a class-wide basis. Then they're seeking for them to be trebled, and then they're seeking for them to get their attorney's fees. So it's not an issue where, this isn't a case where we have a dollar-type claim at issue, where it's someone looking for a coupon rebate or something like that.
What are the rates for the arbitration fees for the commercial I don't know what they are.
You know, Your Honor, I don't know either, but that was mentioned as an issue. This contract has a fee-shifting provision, so
At the end, isn't it at the end?
No, if they can show that there's a burden on him, a substantial burden on him in paying the fees, Dynamex pays them.
As determined by the arbitrator, it doesn't say when.
It doesn't say when, but it doesn't preclude them from being done at the beginning of the case.
But that would not pay his fees with regard to travel.
No, but there's no evidence before you in the record as to how much it would cost to travel to Texas or how frequently he would have to go. The discovery in this case has essentially been done in Massachusetts. It might have been done in Massachusetts in any event, given the Mr. Paquiat's presence here. And all that's left to do, well, there might be some discovery left, but really all that's left to do is an arbitration hearing. There's no evidence that he cannot afford to go to an arbitration hearing, or that it's not worth, or that he wouldn't do so. There's a distinction in American Express between a barrier to actually bringing a claim and making a litigant's decision whether it's worth it to bring the claim. The arguments that they're presenting to you are arguments that it may not be worth it for him to
No,
pursue
I
this
don't
claim.
think, they are distinctly not. I think they are arguing it goes to whether they can bring a claim, because it's financially impossible. I think that's their argument. You may not agree with it, but that's their argument. It isn't like in Dell. It isn't worth it because the damages we would get would be less than what it costs to do. That's not what they're saying.
Well, there's no evidence then in the record before you as to how much it would cost him to pursue a claim in Texas, particularly given the fee-shifting provision in the contract.
So I'm sorry, the agreement doesn't provide for the amount of the arbitration fee?
No, it's a schedule from the AAA, and I apologize, I don't have those fees at the ready, but they do, again, they do provide for Dynamex to pay those fees if they're a burden to the plaintiff.
The arbitrator, but it doesn't speak as to whether they're to be advanced and whether that's to be done at the conclusion of the hearing?
No, but it doesn't preclude Mr. Paquiat from applying to the AAA for that decision early in the case.
If he loses, he has to pay your attorney's fees, correct?
If he loses this matter, we would not interpret that provision this way, Your Honor.
If action is necessary to enforce the interpret the terms of this agreement, the prevailing party shall be entitled to recover his attorney's fees. That doesn't mean he's going to have to pay yours if he loses.
Well, we haven't brought the action to enforce this, and again, we've never claimed that we would be seeking his attorney's fees. We don't have a counterclaim for that.
I'm sorry, your time is up.
Thank you, Your Honors.
Thank you.